Good afternoon, everyone. Today I thought I would talk about the difference between a restraining order and a non-molestation order, commonly known as an injunction. It's one of the questions that I get asked most actually by clients and by professionals. And it is quite confusing if you don't know the difference. There is no difference in how they work. They are both designed to stop the perpetrator from being abusive to the victim, should we call it. The restraining order is given by a judge in a criminal court, and a non-molestation order is given by a judge in a civil court. Now, I'll explain the difference really of that. So, if the perpetrator of domestic abuse is charged with a crime and goes to court and is found guilty, sometimes even if he isn't found guilty, the judge can order a restraining order, give a restraining order, and these can last for 6 months, a year, sometimes indefinitely. If you haven't involved the police, but you still want to protect yourself, you can go to the civil court, so a county court, and you can ask the judge for a non-molestation order, injunction. And he can also order those for 6 months, a year, or indefinitely. You need to give statements of evidence. So, when I say evidence, it's not really. Nobody should have to prove that they've been through domestic abuse, but there will be an affidavit, some sort of statement that lists 2 or 3 incidents of abuse. And remembering, of course, that now it doesn't have to be physical abuse. It can be coercive control, emotional abuse, all of that. And then the judge will, if he feels that there is a good reason to give an injunction, most of the time there will be, he will give that non-molestation injunction, and it will have a power of arrest attached to it. The restraining order from the court is given by a criminal court. So they both have powers of arrest, which means that if the police are called and that order is presented, so look, I've got this order, he's breaching the order, he is liable to be arrested. Now, I always say it's better to be represented at court. Of course, in criminal court, you don't need to be. You're automatically represented by sort of, the police and the Queen's Counsel, I call them. So, but in the civil court, you're not. So I would always say it is better to be represented by a barrister. But of course, that costs money. And some women, there's just no way they can afford that. They may work and not be entitled to legal aid, and or any number of reasons really. If you go to a solicitor and you do it that way, you're looking at a cost of £2,000 upwards. So it's not cheap. It's a lot of money. If you can get legal aid, if you're entitled to legal aid, of course you don't have to pay. Or there is the National Centre for Domestic Violence, and they are very, very good. And I've had many clients who have used the National Centre for Domestic Violence, and they sort it all out for you. All you've got to do is turn up to court. I have loads of these leaflets and cards, so if anyone wants me to send the information out to you, I'm very happy to do that. Just drop me an email. I'll give my email address at the end of this video. Indeed, if you've got any personal issues or requests or questions around restraining orders, non-molestation orders, please email me and I can give you a more personal advice about it. But this is just kind of a summary really. Yeah, so it costs about upwards of £2,000. It's a lot of money, but there are ways around it, and the National Centre for Domestic Violence is one of them. Still have to go to court. Now, the thing with a civil order, a non-molestation order, is that you can get it what we call ex parte. So if there's been a fairly recent incident of abuse, you can ask for a non-molestation order without the perpetrator knowing about it. And this would be because you are afraid of the repercussions of this. So you would ask for it first. Now, in that case, you would go to court. The judge would have all the paperwork in front of him, and or you would be represented. And if he gave the order, he would give it usually for a couple of weeks, a week or 2 weeks. And then the perpetrator would be served the papers. And that would be the first time that he had heard anything about it. He's then given an opportunity, because he has to, by law, be given an opportunity to state why he doesn't agree with it. In my experience, most perpetrators don't turn up to court. There's a return date to court made, and it's given in the papers that he is given by the server, and then he's got the opportunity to turn up to court and state why he doesn't think the order should be extended. If he doesn't turn up, the judge will extend it, and that's usually, again, as I said, for 6 months, a year, or indefinitely. If he does turn up, then he can state why he doesn't want it to be extended. In my experience, they very rarely, perpetrators very rarely go to that court date and say why it shouldn't be extended. I can't even think of the last time that happened with any of my clients. It's possible, they can, but it's very unusual. And even then, if there's enough evidence in those statements before the judge to suggest that abuse has happened in any of its forms, the judge will extend it anyway. The thing to remember is, if you're going to do it ex parte, you need to make sure that you're safe when he is given those papers. So if you're still living with the perpetrator, it may be a good idea to go somewhere else, I don't know, family, friends, sort something else out, get yourself some support from an IDVA, such as me, because obviously he's not going to be happy when he gets those papers put in his hand. If you don't do it ex parte, if you just make a date to go to court and he's notified of it, then you don't have to go back to court. It's dealt with on that day. But I don't know, because of the nature of domestic abuse, I don't know of many women that do that kind of do by date application. It's usually ex parte, because you need to be protected like there and then. How long does it take to get to court? Usually, I would say usually a few days. If the incident has been serious, if there is a physical abuse, and you're really in fear for your life, then, and you still don't want to involve the police, then you can usually you can get in sooner. And I've got women into court sort of the next day before now, but that's generally if you use a solicitor and barrister. So you're looking at probably about a week, or so, something around that. Now, if the difference with a civil order as well is that the police don't know about it necessarily. What should happen is copies of the order should be sent to the police station, and you can do that yourself. But in my experience, any manner of things can go wrong with that. They could get lost in a system, so they don't necessarily need to know that there's a non-molestation order in place. But if that order is breached, and you call the police, you call, say for example, you call 999 and say, you know, he's here, he shouldn't be here, I've got an order. The police come, they will see the order, they will arrest him, and then it becomes a criminal matter, because then he will be taken to criminal court for breach of the civil injunction. Now, it kind of can get a bit confusing, but that's kind of the gist of it. Now, there are all sorts of other orders that can be attached to a non-molestation order. There's an occupation order, for example, so somebody to if somebody wants to remove the perpetrator from the property. I'm not going to go into that because that's slightly more in depth and it will make this video too long. But if anyone wants to, I probably will do a video about occupation orders. And there's lots of different orders that can be used in where there has been domestic abuse. There's prohibited steps order, occupation order, all sorts of child arrangement orders. All different orders can be used and got from civil courts. But the main basis of this video is the difference between a restraining order and a non-molestation order, and the difference is that the restraining order is from the criminal court and the non-molestation order is from a civil family court, county court. They mean the same thing. They will both say not to contact a certain person. You can have things written into them like not to contact via social media or text message, or instruct anybody else to contact on your behalf. It's all down to your particular situation, really. They mean the same thing, and the perpetrator can be arrested as a result of breaching both of those. It's just where they are issued, whether it's a criminal court or the family court. And that's it. So I'm going to end now because I've kind of made this quite a long video. But if you have got any, I hope I've made sense. I tend to ramble a lot when I'm talking to a computer. But if you have any sort of specific personal questions about those orders, or any orders really, just drop me an email at sharon@sharonbryanconsultancy.com. As always, please leave comments on YouTube channel, and yeah, that's it. So I'll be back very, very soon with another topic to talk about, and maybe I will talk about occupation orders next time. But if there's anything specific you want me to talk about, then drop me an email, let me know, and I'll do my best to do that. Let me know if you're enjoying these videos by commenting on YouTube, and I'll see you very soon.